You asked what happened after the will reading. A lot of you said the same thing in different words. What did the documents actually show? Did my brother get away with it? What was on that recording? So here it is. I'm not leaving you with questions this time. My grandmother raised me from the time I was 9 years old. My mother left when I was 8, which is a story for another day, and my father was already gone before that. My grandmother, Nora, she stepped in without being asked. She didn't hold it over me. She didn't use it. She just did it, quietly and completely. The way people love when they're not keeping score. I grew up in her house on Clover Ridge Road in Asheville, North Carolina. I learned to drive in her driveway. I graduated high school wearing a dress she hemmed by hand at the kitchen table at midnight. That house was never just a building to me. It was the first place I felt safe. I became a home health nurse because of her. Because I watched how she cared for people and I wanted to do the same thing. For the last 4 years of her life, after she was diagnosed with early-stage vascular dementia that slowly took more from her than any of us wanted to acknowledge, I rearranged my entire life to be near her. I moved back to Asheville. I took on fewer shifts. I was at her house 5, sometimes 6 days a week. I coordinated her medications, her doctor's appointments, her in-home aid schedule. I was the one she called at 2 in the morning when she was confused and scared. I was the one who held her hand during the hard appointments. I was the one who helped her attorney update her estate documents when she told me clearly, on a good day, that she knew exactly what she wanted, and she didn't want any confusion after she was gone. My brother, Derek, lives in Phoenix. He visited twice in 4 years. Once when he needed money and once at Christmas, where he stayed for exactly 3 days and spent most of them telling my grandmother she should sell the house and move somewhere easier to manage. He has a wife, Tanya, who has never made any secret of the fact that she views my grandmother's assets as a delayed inheritance she's been waiting on. I say all of this not because I want to paint them as villains. I say it because context is the only thing that makes the rest of this make sense. My grandmother passed on a Tuesday in February. She died at home, which is what she wanted. The hospice nurse was there. I was there. Derek was not there. He arrived on Thursday, 2 days later, and by Friday morning, before she was even in the ground, Tanya was walking through the house with her phone out, photographing furniture. The funeral was hard in the way that only quiet funerals are hard. Not loud grief, just the kind of absence that settles into rooms and stays. I got through it by keeping busy, by being useful, which is a habit I learned early. After the service, my grandmother's attorney, a man named Glenn Harwick, reached out to confirm a meeting date for the reading of the will. He told me the date, told me the location, his office on Lexington Avenue, and told me there were documents I should know about that went beyond a standard will. He didn't say more than that on the phone. He didn't need to. I already knew what she had done because I had been present when she did it. What I didn't know was what my brother had done in the 48 hours between the funeral and that meeting. I pulled into Glenn's parking lot at 9:40 that morning with a folder of documents I'd been keeping since the beginning: her updated medical power of attorney, the hospice intake forms, a printed copy of her trust summary she had given me herself and asked me to hold on to. I had everything in a green folder, the kind with the elastic band, and I carried it the way you carry something you've protected for a long time, carefully, quietly, without drawing attention to it. Derek and Tanya were already in the waiting area when I walked in. Derek was in a button-down shirt I had never seen before, which told me he had planned this differently than he had planned the funeral. Tanya had a leather portfolio open on her lap. She looked up when I walked in and smiled, the kind of smile that doesn't reach the eyes. We didn't hug. We didn't exchange more than the minimum. Glenn came out at 10, shook hands, led us into the conference room. He set a file on the table between us. Neat, labeled, the kind of organization that signals someone has been thinking about this for a while. He explained the structure: a pour-over will, a revocable trust established 8 years ago and amended twice, the second amendment made 14 months before my grandmother died. He laid out the terms clearly. The house on Clover Ridge Road was already outside probate, titled to the trust. The trust held 2 savings accounts, a brokerage account, and the proceeds of a life insurance policy. Total assets approximately $940,000. Primary beneficiary named in the amended trust, me. Derek's jaw tightened the moment he heard the number. Tanya's leather portfolio snapped shut. Glenn continued. A limited distribution to Derek was included a one-time payment of $15,000, contingent on timely cooperation with trust administration and no contest of the estate documents. Derek's voice came out slow and controlled. He said he had concerns about the amendment. He said he had reason to believe my grandmother was not lucid when the changes were made 14 months ago. He said he had documentation. Tanya opened the portfolio. Glenn looked at the papers they slid across the table. I opened my green folder and took out one document and placed it on the table in front of him. It was the hospice intake cognitive assessment, completed 11 months before she died. Not 14 months ago, 11 months. After the amendment. Administered by a licensed clinician. At the bottom, a score and a clinical notation that read, patient-oriented to person, place, and time. Patient verbalized clear preferences regarding care and family contact. No evidence of decisional incapacity at time of assessment. Glenn looked at it. Then he looked at Derek. He said he appreciated Derek raising concerns and that they would need to address them properly. He also said he could not in good conscience proceed informally given what had been submitted by both parties, and that if Derek intended to contest the trust amendment, that would need to happen in court. I thought that was the whole day. I thought we were going to shake hands, walk out, and let the attorneys handle the paperwork. I didn't know yet that while I was at the funeral 2 days earlier, Derek had gone to my grandmother's house alone and removed a box from her bedroom closet. I didn't know he had taken physical documents, the original signed trust amendment, her handwritten letter of instruction, and a small thumb drive she kept in a blue velvet pouch on the top shelf that I hadn't even told him existed. I found out the next morning when Glenn called me. He was careful on the phone. He said Derek had submitted a competing document to the court, a version of the trust amendment with a different beneficiary distribution, one that split the estate equally between Derek and me. The document had my grandmother's signature on it. Glenn said the execution date was listed as 2 weeks before the date of the actual amendment on file with his office. He said he wanted me to come in immediately. I sat in my car in the parking garage for a few minutes before I drove over. Not because I was afraid of the outcome, because I had to decide how angry I was going to let myself be before I walked into a room where anger would not help me. I decided not very, because I had something Derek didn't know I had. 14 months ago, when my grandmother asked me to drive her to Glenn's office to sign the amended trust documents, she had done something I thought was unusual at the time. Before we left the house, she sat at the kitchen table, opened her laptop, and recorded a video message. She talked to the camera for about 9 minutes. She said her name, the date, her address, what year it was, who the current president was. She said she understood she was updating her trust. She said she understood what she was changing and why. She said she was not being pressured by anyone. She said, and I remember this line exactly because it went through me like cold water when I heard it. I know Derek will be upset. I know Tanya will be worse. I've thought about it for a long time and I know what I want. She sent the file to Glenn's email before we left for his office. He had it in her client folder. He had never needed to use it. Until now. When I got to Glenn's office, he already had his associate, a younger attorney named Priya, reviewing the competing document Derek had submitted. Priya looked up when I walked in and said, quietly, that she had significant concerns about the execution date and notarization on the version Derek submitted. She said the notary commission number on that document had expired 6 weeks before the listed signing date. I set my green folder on the conference table. I told Glenn about the video. He looked at me for a moment and then picked up his phone. We went to Buncombe County Circuit Court 3 weeks later. I want to be precise about what that room felt like, because a lot of you have been in rooms like that and you know the specific weight of having to prove something that should never have needed proving. My brother was already seated when I walked in with Glenn and Priya. He was in the same button-down shirt. Tanya was beside him, but she wasn't allowed at counsel table, so she sat in the gallery directly behind him where she could pass notes over his shoulder if she wanted to. Their attorney was a man named Rowe who spoke the way people speak when they've spent decades making bad behavior sound reasonable. The judge was a woman named Judge Caldwell. She didn't make small talk. She opened with the competing document, and she looked at it for a long moment before she looked up at Rowe. She said she had reviewed the notarization records. She said the commission number on the document Derek submitted belonged to a licensed notary whose commission expired on August 3rd of the prior year. She said the execution date on the document was August 22nd of the same year. She asked Rowe to explain. Rowe stood and said his client had obtained the document in good faith and was not personally responsible for verifying notary credentials. He said the important question was the underlying intent of the decedent. Judge Caldwell looked at him for a moment. Then she said, with a notary commission that had already lapsed, this document has no legal execution. She said she was not going to spend time on intent until the instrument itself could be authenticated. She asked whether Derek had any other version of the document, or any explanation for how a document came to carry an expired notarization. Rowe said they were investigating. Judge Caldwell said that was not an answer. Rowe said they would need time. Judge Caldwell said time was not what this hearing was for. Then she turned to Glenn. She asked whether the trust had a valid execution on record. Glenn said yes. She asked whether the trustee had documentation supporting the decedent's capacity at time of execution. Glenn said yes. She asked whether he wished to present it. Glenn said he did. He introduced the video first. He explained what it was, a voluntary statement recorded by my grandmother in her own home on the date of execution, prior to leaving for the attorney's office, sent via email to the attorney's file at her own initiative. He gave the court the email timestamp, the file metadata, the chain of custody. Judge Caldwell asked whether Roe had any objection to its admission. Roe stood and said the video could have been staged, could have been coached, could have been recorded under pressure. He said without corroboration, it was self-serving. Glenn said, "Your Honor, we have corroboration." He introduced the hospice cognitive assessment next. Then the updated medical power of attorney signed 4 months after the trust amendment, which carries its own 2-witness notarization. Then a letter from my grandmother's primary care physician documenting that at her last office visit, 7 months before she died, she scored within normal ranges on her standard cognitive screening and was described as alert, oriented, and capable of medical decision-making. Judge Caldwell looked at the stack of documents. She looked at Derek. She asked whether his position was that his mother was not competent at the time of the trust amendment. Roe started to answer. Judge Caldwell held up a hand. She said she was asking Derek. Derek shifted in his seat. He said he believed his mother had been influenced. He said the amendment didn't reflect what she would have wanted if she had been thinking clearly. Judge Caldwell said, "And your basis for that belief?" Derek said he knew his mother. He said they were close. There was a pause in the room that had a specific texture to it, the kind of pause that happens when something true and something claimed exist in the same space and cannot both survive. Judge Caldwell said, "You visited twice in 4 years. Is that correct?" Roe moved like he was going to object. Judge Caldwell looked at him, and he sat back down. Derek said he lived in Phoenix. He said the distance made it difficult. Judge Caldwell said she wasn't criticizing the distance. She said she was establishing contact. She looked at her papers. She said the trust amendment and supporting documents indicate the decedent referenced her caregiving arrangements specifically. She asked Glenn if the letter of instruction was available. Glenn said it was. He retrieved it from his folder. A handwritten letter, 3 pages, on the pale blue stationery my grandmother kept in the top drawer of her writing desk. Glenn passed copies to both tables and to the court. I had not read it in full before that moment. I had known it existed. I had not known everything she put in it. The clerk read it into the record. My grandmother's handwriting had always been neat and deliberate, and whoever had scanned it had done so carefully. Listening to those words in that room was one of the harder things I have done. She wrote that she understood her health was declining and that she wanted her wishes documented clearly so there would be no dispute after she was gone. She wrote that I had given up professional opportunities to be near her during her illness, and that she had seen that sacrifice every day and she did not take it for granted. She wrote that she loved her son and that she knew he had his own life and his own reasons for the choices he made, and that she forgave him for the distance, but that forgiveness was not the same as trust, and trust was what a final document required. Then she wrote the line that went through the room the way my grandfather's dispatch recording had gone through the courtroom in the video I studied. She wrote, "I am not being pressured. I am the one doing the pressing. I have wanted to make these changes for 2 years, and I am making them now before I lose the ability to say clearly what I mean." Tanya made a sound behind the bar. Not loud, but the kind of sound you make when the ground moves under a belief you've been standing on. Derek stared at the page in front of him without speaking. Judge Caldwell looked at him. She said, "Mr. Weston, we have a video in which your mother stated her intent clearly, dated and time-stamped before execution. We have a cognitive assessment completed after execution confirming decisional capacity. We have a letter of instruction in her own hand, stating explicitly that she was acting without pressure." She asked what remaining basis he had for contesting the amendment. Roe tried. He said the cognitive assessment was completed by a hospice clinician rather than a neurologist and should be given limited weight. He said the video was shot at home without independent witness. He said the letter, while moving, was not a legal instrument. Judge Caldwell said she was not asking what weight to assign individual pieces. She said she was asking whether, taken together, he could articulate a good faith legal basis for contesting capacity. Roe said they believed they could. Judge Caldwell looked at him for a moment. Then she said she was going to move on to the competing document. She asked Roe to identify who had executed the notarization on the version his client submitted. Roe said they were still confirming details. Judge Caldwell said she had the commission records in front of her. She said the name on the document was a licensed notary named Carl Petrie, whose commission had been active until August 3rd, and whose records showed no notarial acts recorded after his expiration date. She said the execution date on Derek's document was August 22nd. She asked how his client came to be in possession of a document bearing a notarization dated after that commission expired. Rowe said his client had obtained the document and believed it to be valid. Judge Caldwell asked where his client obtained it. Rowe looked at Derek. Judge Caldwell said she was looking at Derek too. Derek said he found it among his mother's papers. Judge Caldwell said she understood that was his position. She said she was asking a more specific question. She asked whether he had been present at any signing involving Carl Petrie. Derek said no. Judge Caldwell asked whether Carl Petrie had ever visited the Clover Ridge Road property. Rowe objected. Relevance. Judge Caldwell said the relevance was that if the document was fraudulently executed, this proceeding had implications beyond civil estate administration. She said she was going to ask the question and she expected a direct answer. She looked at Derek again. Derek's throat moved. Then he said quietly that he may have arranged a signing some time ago. The room shifted. Glenn's pen stopped moving on his notepad. Priya looked up from her laptop. I kept my eyes forward. Judge Caldwell said, "You arranged a signing with Carl Petrie?" Derek said he had thought his mother was going to sign an earlier version of the trust that treated him and his sister equally, and when she changed course, he had tried to get the document executed before the change was finalized. He said he thought it was what she actually wanted. He said he was trying to protect her interests. Judge Caldwell looked at him for a long moment. She said, "Let me make sure I understand your testimony. You arranged for a notary to execute a document on behalf of your mother. The notary's commission had already expired at the time of the execution date listed on that document, and the document was then submitted to this court as evidence in a contested probate proceeding." Derek said he hadn't known the commission was expired. Judge Caldwell said whether or not he knew was a separate question. She said the document itself was legally invalid regardless. She said she was also noting for the record that submitting an invalid document to a court as authentic evidence was a matter she intended to address separately. She said she was referring the issue to the appropriate authority for review of potential fraud on the court. Tanya exhaled behind the gallery rail. It was a sharp sound, the kind that escapes before a person can stop it. Derek turned slightly toward her without turning all the way, and in that half-turn, I saw that their whole plan had just rearranged itself in his mind into something new, something smaller, and much more frightening. Judge Caldwell continued without pausing. She said she was admitting the original trust amendment, the video statement, the letter of instruction, the medical documentation, and the hospice assessment as exhibits. She said the competing documents submitted by Derek lacked valid notarization and would not be admitted. She said the trust amendment on file with Glenn's office was valid and enforceable. She said the estate would proceed to administration under those terms. Rowe stood immediately. He said his client reserved the right to appeal on the question of undue influence. Judge Caldwell said he could file whatever he wished. She said the record before her today did not support a finding of undue influence, and she was not going to delay administration based on a challenge unsupported by admissible evidence. She said distribution would proceed and the trustee would manage assets without interference. Then she looked at Derek directly. She said the contingent bequest of $15,000 to him was suspended pending the outcome of any sanctions or fraud review related to the document submission. She said until that matter was resolved, he would not receive a distribution. Derek stood. His voice cracked at the edges. He said this wasn't fair. He said our grandmother loved him, and she would never have done this if she had understood what she was doing. He said I had manipulated her for years. Judge Caldwell said, "Mr. Weston, sit down." He sat. She said, "We have a video in which your mother, in her own words, dated and documented, stated she was not being manipulated and that she had wanted to make these changes for 2 years. She said she would not revisit that finding. She said if he had additional legal arguments, he could file them through counsel." Then she set down the file in front of her and looked at Glenn. She asked who the named trustee was. Glenn said his firm, with a corporate fiduciary as co-trustee. Judge Caldwell nodded once. She said that was satisfactory, and that administration could commence immediately. She said the fraudulent document referral would be transmitted to the state bar and to the district attorney's office for review. She hit the gavel once, clean and final, and said court was adjourned. Derek and Tanya didn't wait in the hallway. They were already at the elevator when I came through the courtroom doors with Glenn and Priya. Tanya had her phone out and was speaking low and fast in a way that told me she was calling someone to reframe what had just happened before anyone else could frame it first. Derek looked at me once. He didn't say anything. He looked the way people look when they've burned something down and are only now seeing the smoke. I let them go? Glenn walked me to my car and gave me an update on next steps, transfer timelines, account notifications, title confirmation on the house. I listened, and I nodded, and I thanked him. And I meant it genuinely, because Glenn had done exactly what a good attorney does. He kept the record clean. Before he turned to go, he said, "I want you to know your grandmother was very deliberate about all of this. She came in 3 times before the amendment was finalized. She asked questions. She made changes. She brought that video to my inbox before she even left her driveway." He paused. "She knew what she was doing." I said, "I know." He nodded and walked back toward the building. I sat in my car for a little while before I drove anywhere. Not a long time. Just long enough to let the quiet settle into the right shape. 2 weeks later, I received a letter from the district attorney's office, confirming that an investigation had been opened regarding the documents submitted to the court. 3 weeks after that, Glenn forwarded me a notice that Roe had withdrawn from the matter. A month after the hearing, Derek's appeal filing came in at 22 pages. Glenn reviewed it and told me it had no basis in the record and would not succeed. It didn't. The house on Clover Ridge Road is mine now. I had the locks changed, not out of fear, just out of clarity. I walked through every room once, slowly, the way you walk through a place you need to commit to memory properly. Her writing desk is still in the corner of the living room. The pale blue stationery is still in the top drawer. I left it there. There's a framed photo on the kitchen windowsill of the 2 of us at my high school graduation. She's in a yellow dress. I'm in a robe 2 sizes too big. We're both laughing at something just off camera. I don't remember what it was. I don't need to. That picture has been in that spot since 2006, and I'm not moving it. What Derek never understood, what people like him never seem to understand, is that my grandmother was not confused, and she was not passive, and she was not waiting to be saved from her own decisions. She was a woman who had lived a long time and thought carefully and prepared thoroughly and trusted the record to say what her family might later try to deny. She didn't leave me the house and the accounts because I showed up. She left them to me because she wanted to, clearly and in writing, twice on video and once by hand on pale blue stationery. That's what ended it. Not anything I argued. Not any speech I gave. A timestamp. A voice. A judge who read the record and refused to let grief be used as a tool. I went back to Clover Ridge Road the night after the hearing. I sat at her kitchen table with a cup of tea I didn't finish, and I let the quiet be what it was. Then I put my green folder in the filing cabinet in the back room, not because I think I'm done needing it, because some families keep trying until there's nothing left to try. And the only language that has ever worked is the one my grandmother spoke on a Tuesday morning, 14 months before she died, into a laptop camera, at a kitchen table I now sit at every day. She said, "I know what I want. I know what I'm doing, and I'm doing it now before I lose the words. I still have the video. I always will." If this story hit close to home, leave a comment. I read every single one. And if you're going through something similar, or you took care of someone who didn't get to protect their own wishes, I want to hear about it. Hit the like button if this was worth your time, subscribe so you don't miss what's coming next, and I'll see you in the next one.